First case to come before the court today is State of Ohio v. Stacey C. Anderson Jr. You will have up to 15 minutes to present your argument. The appellee has waived argument today, so we're hearing only from you on this case. You should not use any names of minors or children or victims, should that be relevant to your argument today. Please stay behind the podium and keep your voice up. Arguments are being recorded, and we have read your briefs, and we're ready to proceed when you are.
Thank you. May it please the court, on behalf of Stacey Anderson, appellant, the state is waived, but appellant has asked that I appear here today to assert his cause. He wants an opportunity to address the court personally, and our contention is that not only was that denied, but that contrary to the state's brief, that lack of opportunity for allocution was not invited error or harmless error. And I understand that the sentencing, a lot was said. It's a 36-page transcript. A lot of information was presented by defense counsel and the prosecutor. The appellant's mother spoke at length. The court was very inviting and heard all of those statements, and but what was not heard was Stacey Anderson. And a close reading of the transcript on page 19, defense counsel has closed out his statements on behalf of Mr. Anderson, his statements about Mr. Anderson's mental health issues. Mother had already spoken. There was discussion about why he did not participate fully in the pre-sentence investigation. So we have a very limited PSI. I will note for purposes of today, the PSI was docketed at the trial court about 3 weeks after the transmittal of the record, but it was still docketed at the trial court, so that PSI is docketed under seal at the trial court, and I believe that based on how the rules of procedure read, that would still constitute an item of the record because it was actually docketed under seal. Having said that, the court on page 19, I draw the court's attention to that, to look back again at the transcript. The court has asked the state, what is the state requesting? So it's time to ask the prosecutor to speak. At no point, however, did the court address Mr. Anderson. That's the distinction that appellant would like to draw today from the cases cited in the state's brief. It's the prosecutor himself who turned to defense counsel and asked, does Mr. Anderson have anything to say? The quote is, does he want to say anything? At that point, defense counsel addresses appellant Anderson, and Anderson says no to his counsel. But, obviously over court law could hear. But that is not the judge asking defense counsel, and that is not the judge asking Anderson. That is the judge asking the prosecutor, what is the state requesting? The state understands that Mr. Anderson has a right to speak, so it's Mr. Anderson that it's prosecutor that addresses defense,
Counsel,
not the judge. Yes.
Counsel, did defense counsel though directly ask Mr. Anderson if he would like to speak?
He did. Page 19. Yes. But the cases cited by the state have some factual distinctions that bear on whether the error was invited. So I think that based on the state's brief, the error is conceded in the sense that it occurred. It's just a matter of whether it's going to be invited or errorless, or harmless, I'm sorry.
The context of the asking is the issue, or that the judge always must do it personally?
I think the rules are pretty clear. You know, the Rule 32 gives command language. The word shall is used. You know, the rule is that the court shall address the defendant, or, you know, provide the offender with the opportunity to ask why sentence should not be imposed. And the rule is very clear on that, and it's very specific. And the cases cited by the defense or the prosecutor, the court is directing statements. For example, in State v. Clifford out of the 7th District, the court is asking defense, is there anything on behalf of the defense? And it wasn't clear in that case whether the court was addressing the defendant or counsel, and at that point, counsel responds and says, the offender has asked me, the defendant has asked me to say that he is sorry for the offense he committed. Here we have the prosecutor stepping in between the court and appellate counsel. And that's the distinction we would ask this court to draw when looking at this case. Furthermore, in the 12th District case cited by the state in State v. Wesley, the court again addresses defense counsel and says, counsel, anything else to say? And in that case, the Wesley case, counsel says, the defendant's very upset. It's difficult for him to speak. Those are the cases cited by the state regarding invited error. So the distinction, again, the distinction there is that the court specifically addressed defense counsel, or maybe even the defendant in the case of Clifford. But here, the court had addressed the prosecutor, and it was the prosecutor that stepped in, and is the prosecutor who tried to provide Mr. Anderson with his allocution. Furthermore, with respect to whether the error was harmless, the state cites 3 cases, Toledo v. Reese, State v. Emerson, and State v. Reed. 2 of those cases are misdemeanor traffic offense cases, misdemeanor 1 cases, and this is a felony of the 2nd degree, the case at bar, and because of the enhanced penalties that go with a felony of 2nd degree, I think that in and of itself is factually distinctive. It creates a factual distinction. The sentences in Toledo v. Reese and State v. Emerson were mostly suspended. In Toledo v. Reese, the court imposed the mandatory 6-month sentence, but suspended all but 3 days of that sentence. Here, Mr. Anderson received a 4 to 6 year sentence, indefinite on felony 2, plus the mandatory firearm specification sentence. So his sentencing is factually a lot different than those misdemeanor sentences.
Counsel?
Yes.
His own attorney said, do you want to make a statement? His answer, no. That's what the transcript reads. Are we to presume that if the judge had said, do you want to make a statement, his answer would have been different than no? I mean, it's hard to get over the hurdle to take it all the way home.
No, well, and what we have is the Rule 32 directs the court with mandatory language that the court shall ask the offender whether the offender has anything to say as to why sentence should be not imposed.
Right, and
So
I agree with you,
Yeah.
but that just means he can't waive it. In other words, he can't be charged with waiving the mandatory language of Rule 32 directing the court to do it, but does that also make it harmless unable to be harmless or invited error?
No, but I read that language to say, okay, we're at sentencing. Counsel's talking, prosecutor's talking, the judge is talking, maybe the victim's talking. We have a pre-sentence investigation. All this is going on, and all that is leading up to sentencing. This rule is directing the courts to ask the defendant, the offender, in a sense, okay, we've heard everything. The court is now ready to impose sentence. Defendant, tell me why, tell me what you have to say at this point now. We've heard everything else. Now is your opportunity to speak. Tell me what you have to say before sentence is imposed. I read the rule that way. And that did not occur here. We have the mother talking, we have discussions about why he didn't check in with community support services, missing appointments, not getting checked in. The PSI is limited because he didn't cooperate fully with that. All that's going on, but the court did not make Anderson aware that it was time for sentencing, and now it's time for Mr. Anderson to talk. And that is what the rule says needs to be provided.
I believe, counsel, in your brief, you reference this as a last opportunity to speak. Is that how you read the rule?
Yes, I do, yes. And that goes back to, the court letting the defendant know it is time for sentencing. What do you have to say? And the prosecutor, and I wish I paid more attention, and I don't know how many sentencings I've participated in over the years, and I just never really pay attention as to who speaks first and who doesn't, but it's my feeling that it's usually the prosecutor, or almost always the prosecutor, that opens the discussion at the sentencing. The court, what's the state's position? The state gives its rendition. The court discusses the pre-sentence investigation. Defense is given the opportunity to talk about maybe where the PSI is incorrect, or maybe there are things that need to be added, things for mitigation that are outside of the PSI. All that goes on, and then the court would address the defendant. In my view, that's how it goes, and I wish for today's argument I had hard mathematical data to say, this is how these sentences have occurred. Not that I would be able to, assert that into the record, because it's not part of the record on appeal, but it's just a matter of operation of how things normally go, because I do not believe, and I think the transcript bears out, that Mr. Anderson was not aware that the court was ready to impose sentence at that time. And then when the court did impose sentence, Mr. Anderson should have been given that last opportunity to speak. And I don't know if things would be any different at a resentencing, but Mr. Anderson definitely wants to address the court personally. And we would ask that the court look at that and give him that opportunity. In terms of the harmless error, I think I've covered that, and I do want to say something, one thing about the State v. Reed, which is the felony case, and that was a minimum sentence imposed. However, that was the mandatory minimum sentence. We did not have mandatory sentencing here, so we cannot say whether the error was harmless. That maybe Anderson may have been able to allocute and receive a lesser sentence. We just don't know that. I appreciate the court allowing us to be here today. I've concluded the points I wanted to cover. Is there anything that maybe I've left unsaid or uncovered in the court's minds? Okay.
I don't think so. Council, thank you very much for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. So thank you again for your presentation.
Thank you.